Hello friends, very warm welcome to my business law channel. Friends, till now I have covered chapter number 9 till chapter number 9 under the ICA 1872. Today friends, I am going to take up chapter number 10, which is remedies for breach of contract. What headings I am going to cover in this video? First of all, meaning of breach of contract, and then types of breach of contract, and then remedies available to the aggrieved party in case of breach of contract. Suit for damages, suit for rescission, suit upon quantum merit, suit for specific performance, and suit for injunction. Very important question from examination point of view. What are the remedies available to the aggrieved party in case of breach of contract? So let us define, friends, the meaning of breach of contract. What is breach? Breach refers to break obligation imposed by the contract or not to act upon the agreed terms and conditions of the contract. It means party is not prepared to act upon the terms and conditions of the contract. When does breach occur? Breach occurs when a party to the contract, without a legitimate legal excuse, refuses to perform his contractual obligation. Now, what are the two types of breach? Now, before I explain two types of breach, friends, I would like to take up example regarding breach. Now, say A agrees to sell his Honda City car to B on 15th of July for 3 lakh rupees. Now, he has told him that he will deliver the car on 18th of July. Now, what he has done, he has got the advance from B, but he has not delivered the car on 18th of July. Then we will say there is a breach on the part of A person. Now, breach can be of two types. One is actual breach of contract, and second is anticipatory, which is also known as constructive breach of contract. Now, when we talk about actual breach of contract, it occurs in two cases. At the time when performance is actually due, that is on the date of actual performance of the contract. As I've given you the example, there you know that on 18th of July, seller has to deliver the car to the buyer, but he commits breach. Then buyer has a right, he can exercise his remedies against the seller during performance of the contract. Now, it can also occur during performance of the contract. Say A has to deliver 10 computers to B. Now, out of 10, he has delivered 4 computers and the remaining computers he has not delivered. Then also there is a breach of contract on the part of A during performance of the contract. Now, coming to the second type of breach of contract, which is anticipatory or constructive breach of contract. As it is clear from the name itself, in anticipation, party is informed. When a party to a contract rescinds or renounces his obligation before the date of actual performance, it is known as anticipatory breach of contract. Friends, it may take place in the following two ways. One is express and second is implied. What is express anticipatory breach? When the promisor informs the promisee expressly before the due date of performance that he will not perform his obligation. Say on 18th of July, A has to deliver Honda City car to B. But what he does, he informs to B on say 16th of July that he is not going to deliver him Honda City car on 18th of July. Then this will be taken as the example of express anticipatory breach. Now, implied anticipatory breach, promisor by his own conduct renders the performance impossible. Action that indicate his intention not to perform the contract. In this given example, friends, the B comes to know that A has, sold this Honda City car to C person on 16th of July. He has not informed him, but through his behavior reveals that, he has sold that car to somebody else on 16th of July. So this will be the example of implied anticipatory breach. Now the question arises, what are the consequences of anticipatory breach? There are two options available to the aggrieved party in case of anticipatory breach. One is to sue the promisor for the breach of contract immediately without waiting for the due date of performance. Continuing with the same example which I have given you, here B person on 16th, when he comes to know that he has been informed that seller is not going to deliver him the car on 18th of July. He can treat the anticipatory breach as actual. That is 16th of July. He can put an end to the contract and he can take actions against A person, the defaulter person. And this promisee, B, will be executed, will be excused from performing his part of obligation. And the second option available to him is to treat the contract as alive. He can keep the contract as alive. He can treat the contract as alive till the actual date of performance. Then he will have to wait. He may elect to treat the contract as alive. And if he does so, he has to wait till the actual date of performance. So he has come to know on 16th that he is not going to get Honda City car on 18th, but he wants to wait. He does not want to put an end to the contract on 16th of July. He wants to wait till 18th of July, which is the actual date of performance. If he gets Honda City car from the promisor, he will pay the price. If he does not get Honda City car, then in that case, he will put an end to the contract on 18th of July. Now, we do talk about assessment of damages. How are damages ascertained? We say that aggrieved party has a right to claim damages from the guilty party. And now the question arises, how to ascertain the amount of damages? There is a formula for that, and that formula is amount of damages is equal to contracted price minus price prevailing on the date of performance of contract. If actual price is the price prevailing on the date of performance of contract is more, it means that now the party goes in the market, buys the item from the market, then the party will have to pay more price. So in this case, the difference between the two will be the amount of damages. A agrees to supply 10 bags of rice to B on 15th of April. A at a fixed price, and on 10th of April he informs that he will not deliver him on the due date. In this case, B can wait till 15th or keep the contract alive. If A delivers the goods by 15th, then B will pay the price. And if A fails, then B can exercise legal remedies. Friends, I hope you must have understood the content till now. And now after that, the heading is remedies for breach of contract. Very, very important question from examination point of view, that which remedies are available to the aggrieved party in case of breach of contract. 5 basic remedies for the breach of contract include the following: suit for damages, suit for rescission, suit upon quantum merit, suit for specific performance, and suit for injunction. Now I take up all the points one by one. The very first point is suit for damages. What are damages? Damages are always allowed by way of monetary compensation. As the aggrieved party has suffered certain loss in terms of money, so that party must be compensated by the guilty party. There is a leading case law regarding this, which is Hadley versus Baxendale. So there are 4 types of damages: general or ordinary damages, special damages, exemplary, punitive, or vindictive damages, and the last one is nominal damages. Now, general or ordinary damages, they're always allowed for direct loss. Special damages, they're always allowed for remote loss or indirect loss. Special damages are allowed only if special circumstances are made known to the other party. Exemplary, punitive, or vindictive damages are always allowed in 2 cases. First is in case of a breach of contract of marriage, and second is in case of dishonor of a check. And nominal damages are allowed for namesake. where the loss is negligible, but the aggrieved party is bent upon to file a suit against the guilty party. So friends, I would like to explain this Hadley versus Baxendale is considered to be the foundation of the law of damages in England as well as in India. Now in this case, Hadley had broken crank shaft sort of machinery, which he had given, the machinery was not working, he had given to B, common carrier, to be taken to the manufacturer for replacement. But he did not inform the common carrier that undue delay on the part of common carrier would result in loss of profits to X mill, because he was the owner of mill. And what happened, there was undue delay on the part of common carrier to get it replaced. With the result, there was no manufacturing machinery, work could not take place, workers had to be displaced, and which resulted in loss of profits to the owner of the mill. So owner of the mill filed a suit against Baxendale common carrier for all these, whatever losses he suffered, and it was held in the court of law since no time limit was given by Hadley to common carrier. So he was entitled to get only the general damages. So general damages are always allowed for direct loss. As against this, special damages. Continuing with the same example, case law. If Hadley had told the Baxendale that, look, you will have to get it replaced within 15 days time. Otherwise, this will result in non-availability of production and which will result in loss of profits. And still, common carrier does not care about this, and there is undue delay on the part of common carrier. Then, in that case, Hadley would have been entitled to get special damages from the other party. So remember, friends, special damages are allowed only when special circumstances are made available to the other party. Exemplary, punitive or vindictive damages, I have told you, in case of breach of a contract to marry, the sentiments of the party will be hurt. So here, friends, the damages will be punitive damages. They are always allowed by way of punishment. Or in case of dishonor of a check, if there are sufficient credit to the funds to the credit of the customer, the banker has no right to dishonor the check. Still, the check is dishonored. Then in that case, the punitive damages will be thrust upon the banker. And nominal damages, where difference is not much, difference between the contracted price and the market price is not much, then nominal damages are allowed. Now moving ahead, friends, there are rules regarding assessment of damages. And these rules have been made available under sections 72 to 75 of ICA 1872. So friends, most of the points I'll be touching, they are self-explanatory also, or these terms and all I have covered under my earlier video classes. And if you find any problem, friends, then you can always write in the comment section, and I will take up one special lecture on rules regarding assessment of damages. Now, suit for rescission. The second remedy available to the injured party is suit for rescission. Rescission means repudiation or termination of contract. Party would like to put an end to the contract. When one party to the contract commits breach of the contract, the other party may sue for rescission and refuse further performance. The party is excused from performing his part of obligation. If rescission allowed by the court, then aggrieved party is discharged from all his obligations under the contract. Now the question arises, when the court may grant rescission. According to Section 27(1) of the Specific Relief Act 1963, it may be granted in the following two cases: where the contract is voidable at the option of the plaintiff and where the contract is unlawful. And you all understand, friends, the meaning of the term unlawful. For causes not apparent on its face, and defendant is more to blame than the plaintiff. So these are the two cases where the rescission will be granted by the court. Now, consequences of rescission, already I have talked about, friends. I will move ahead now. Suit upon quantum merit. This is the third remedy which is available to the injured party in case of breach. What does it mean? It means proportionate payment. As much as earned or as much as merited. Many times what may happen? Say the party has not performed his part of obligation totally. There is partial performance. Will that party be entitled to the payment or not? Proportionate payment or not? This is the question. So, proportionate payment in relation to the work done, as much as earned or as much as merited. This is the meaning of the term quantum merit. So, which are the cases where the claim for quantum merit arises? 6 cases are there where work has been done in pursuance of a contract which has been discharged due to breach by the defendant. Other parties prepare to do the work, but defendant says, do not do this work. 75% of the work has been done, 25% is left out. Then he says that you do not complete this work. Maybe he's not satisfied. Then in that case, it means whatever 75% he has done it, he must be paid for that. Where services have been rendered under an agreement which is discovered to be void or under a contract which becomes void. Say a person was appointed as managing director in the company. He worked for 3 months period. But after that, he came to know that managing selection committee which appointed him, the constitution of that committee was not legal. Then, friends, agreement is discovered to be void. It does not mean that person should not be paid for 3 months. He will be given the salary for 3 months period for which he has worked. Where a person enjoys the benefit of non-gratuitous act. A person has rendered certain services on non-gratuitous basis with the intention of getting reward. And the other person has enjoyed the benefit of that. Then also, one can sue on the basis of quantum merit. Where a contract is divisible, a person who is guilty of breach may also sue if the following 2 conditions are satisfied. That is, the contract must be divisible, not entire. Entire contract is where the payment has to be made on the completion of the contract. If the party leaves the work in between, party will not be entitled to the single payment. And the party has enjoyed the benefit also when they had a choice to decline it. So benefits must have been enjoyed and the contract must be divisible. Coming to next point, friends, which is where an entirely indivisible contract is completely performed but badly. That is, contract has been performed completely, but it was not up to the satisfaction of the owner. Then also, friends, it means, say, a decorator. Take the example of decorator. Owner of the house contacted the decorator for decorating his house. Work was done, but certain portion was not up to the satisfaction of the owner. The owner contacted another person for this and paid him, say, 250 charges. Then in that case, from the total amount 250 charges, 250 rupees will be deducted. And the remaining amount will be given to the decorator. Where there is express or implied contract to render services, but there is no agreement as to remuneration. Even if there is no agreement, but there is express or implied contract as to render services, but there is no agreement as to remuneration. Then also one can get the remuneration if the person has provided the services. Now, moving ahead, the 4th remedy is sue for specific performance. Cases where specific performance may be enforced. What is the meaning of specific performance of contract? Specific performance of the contract means carrying out the actual obligations of the contract. If there is no standard for ascertaining the actual damage, if monetary compensation is not the actual remedy, then the person can apply to the court for specific performance and the specific performance will be granted. There is no exact substitute or alternative to the subject matter of contract. That is, subject matter is not available in the market. It is usually granted in contracts connected with land, building, rare articles, unique goods which are not available in the market. Only that person had. And then also the party can go to the court, knock the door of the court, and bring injunction order against the bring specific performance order against the guilty party. And granting suit for specific performance is at the sole discretion of the court. Party cannot take it as a matter of right. The party can request only. If the court thinks that order should be given for specific performance, then the order will be given. Now, exceptions of specific performance of contract. Where monetary compensation is inadequate relief, then in these cases, the specific performance of the contract will not be granted. Where the court is of personal nature, where the contract is of personal nature, that is, the performance is dependent upon special skills and talent of the promisor. Where the contract is made by a company in excess of powers laid down in the memorandum of association. Where the contract is made by the trustees in breach of their trust. Where the court cannot supervise its execution. In case of building construction, dam construction, it is not possible for the court to supervise the execution of the contract. There also specific performance order will never be granted by the court. And the last is suit for injunction. What is injunction? It is an order of the court which directs a party at fault to actually perform the negative obligation or terms of the contract. It refers to requesting the court to issue stay order against a party at fault. Injunction order remedies particularly appropriate in case of anticipatory breach of contract, where damages do not provide an adequate remedy. This remedy is exercised only where negative terms are contained in the contract. So just now, friends, I have told you that one of the cases where specific performance is not guaranteed is contract of personal nature. You all understand. I hope you all understand and the meaning of contract of personal nature. There is a leading case regarding this, which is Lumley versus Wagner. Wagner gave the promise to give her singing performance at Lumley's theatre for certain days. And then what happened? At the same time, Wagner also gave the performance during the same days, the same time at Zed's theatre. And L went to the court and requested the court to issue the prohibitory order, injunction order. So then court gave the order to Wagner not to give her performance at Zed's theatre. In a way, this injunction order is securing specific performance of the contract in the negative terms. Wagner was not allowed to give her performance at Zed's theatre, meaning thereby Wagner had to give her performance at Lumley's theatre only. Very important case law regarding this fifth remedy, which is suit for injunction. Friends, now I would like to conclude what I have covered in my today's lecture class: the meaning of breach, types of breach, actual and anticipatory, and then I talked about types of damages, 5 remedies available to the aggrieved party in case of breach. I hope you must have understood the content. If you have any problem, then you can always write in the comment section. Do like my videos, do subscribe to my channel, do press on the bell icon to get notification of my future videos. Stay blessed always and stay healthy. Okay friends, goodbye. We'll meet soon. Bye-bye, bye-bye, bye-bye.